Good afternoon, everyone. Thank you for joining us today at the Mayflower. I'm Elizabeth Slattery. I'm the Director of Practice Groups at the Federalist Society. Our program today is sponsored by the Federalist Society's Free Speech and Elections Practice Groups. Many thanks to the leadership of these groups, particularly our Elections Executive Committee Chair, Alan Dickerson, who was instrumental in putting together today's event. We are excited to gather today for this panel discussion exploring the legacy of the Supreme Court's ruling in Buckley versus Valeo, which was decided 50 years ago this winter. Regrettably, our keynote speaker, Professor Joel Gora, has been caught up north because of the blizzard. But in his place, Bradley Smith has agreed to deliver Professor Gora's prepared remarks. So he's going to do his best impression for us. Brad needs no introduction among this group. He's a leading expert on campaign finance law and served as a commissioner on the Federal Election Commission. Brad is Professor of Law Emeritus at Capital University Law School and chairman and founder of the Institute for Free Speech. Brad is also a longtime member of our Free Speech and Elections practice groups. So Brad, the floor is yours.
Thank you, Liz. Thank you. So, yeah, I'm not Joel Gora, which is unfortunate because Joel speaks to this as one of the counsel who actually argued the case in the Supreme Court. You know, there's an apocryphal tale that William Brennan was appointed to the Supreme Court because he pinch hit for one of his colleagues on the New Jersey court and gave that person's speech, and AG, the Attorney General Brownell, heard the speech and said, "This guy's great, we got to put him on the court." And there's actually some truth in that. He was pinch hitting, but he did give his own speech. He didn't just read someone else's remarks. But maybe he did. Maybe I can get a Supreme Court appointment out of this. In any case, Joel's remarks are very personal, as you'd expect from someone who was arguing the case 50 years ago. And so there will be a lot of I and we and us and our, but note that that is not me. That is Joel, and I am very much not an East Coaster. I cannot speak like a New Yorker at all. So you'll just have to imagine it in your head, speed it up a little bit, and put a little accent on it. And it's an honor for me, actually, to be able to deliver these remarks for Joel. So Joel first wanted to thank Alan Dickerson for inviting him to the program and Shayla for her help and support, and thanks to all of you for attending and for understanding his absence today. This means Joel now, have been privileged to spend my entire professional career working in the area of constitutional law, and especially the protections of the First Amendment. As a full-time lawyer for the ACLU for a decade, and a volunteer thereafter, once I started teaching at Brooklyn Law School, I've worked on more than 100 Supreme Court cases, most dealing with the First Amendment rights. I am one of the one I'm proudest of, and which has the greatest positive impact on political freedom, is the Buckley case, whose 50th anniversary we celebrate today. It was a watershed moment for the court and for the country. Years later, when politicians sought to pass increasingly restrictive federal campaign finance laws, a Democratic leader was asked about whether they posed a problem under the First Amendment. His response was, in effect, you can either have free speech or fair and healthy elections, but you can't have both. My response, this is Bradley Smith aside, that was Dick Gephardt, actually. Back to Joel, my response was precisely the opposite was true. You can't have one without the other. Free speech is not the enemy of democracy. Free speech is the engine of democracy. It is the most powerful political tool we have to control the government. To allow the government to control free speech is to take away that tool. And that was what was at stake in Buckley, and the court did an outstanding job, if not a perfect one, of protecting that vital tool. In Buckley, the court dealt with the most draconian federal restrictions on political speech and association since perhaps the sedition laws of 1798. But Buckley was not the first modern case to deal with these issues. That honor belongs to a case that arose in 1972, 4 years before Buckley, when Congress had passed the new Federal Election Campaign Act of 1971. That law used two methods to try to curb supposedly excessive political spending. One was much greater disclosure of federal political contributions of more than $100. The other was a Rube Goldberg device to try to limit political media communication expenditures. The law set specific numerical limits on the amount that candidates for different federal offices could spend. Candidates had to certify to the news media running a political ad that it would not cause the candidate to exceed the limit. And worse, independent speakers had to obtain certification from any candidate who benefited from their media expenditure. So if your group wanted to run an ad supporting a candidate, you had to get approval from that candidate. And if you wanted to run an ad opposing a candidate, you had to get approval from that candidate's opponents. In effect, candidates were given a veto over speech helping their cause. And the media entity could not accept the ad without those certifications, or it would face criminal prosecutions. The first enforcement target under this bizarre new law was not some well-heeled individual or powerful group. It was a small group of anti-war protesters and activists who had run a 2-page ad in the New York Times advocating the impeachment of President Richard Nixon for committing war crimes by bombing Cambodia and praising a handful of members of Congress who had voted in favor of the impeachment resolution. You would have thought they would get a medal for their civic participation. Instead, they got a visit from federal agents who wanted to know who they were, whether they had formed a political committee, and who were their officers and contributors, and did they know that they had violated the law by running the ad without complying with those requirements or presenting the New York Times with certification that the ad would not cause any of Nixon's opponents or any of the opponents of the several members praised in the ad to exceed their respective media communication limits. It's hard to believe, isn't it? Those would have been utterly impossible Herculean task, and all for running an ad criticizing the President of the United States and his policies. The government got a federal district court injunction barring the group from doing this, again without complying with the FACA. The group came to see us at the ACLU, and we could hardly believe their story. But as we looked at the matter more closely, we realized that this new law was not reform. This was a stunning repression of political speech and association, and we represented those dissenters. The government's theory was that it was an election year, that President Nixon was up for re-election, and that therefore media ads criticizing or supporting him fell under the brand new FACA. We were stunned. The idea that you could be punished by the government for public criticism of the President of the United States seemed inconsistent with everything we understood about the First Amendment, which was designed to encourage criticism of the government, not to stifle it. Fortunately, we were able to persuade the lower courts that if groups were not permitted to be that were not partisan but issue-oriented, they should be allowed to engage in this speech without prior restraint or penalty. And so we breathed a sigh of relief. But then, around the same time in the early 1970s, Watergate happened. One issue in Watergate was Republican campaign finance irregularities, even though most of those donations were already either illegal or subject to disclosure. Spurred by those reports and President Nixon's resignation, Congress quickly passed 1974 amendments to the Federal Election Campaign Act, which enacted numerous new and far more burdensome restrictions and prohibitions on campaign funding. These amendments were what gave rise to the Buckley case. Massive new restrictions limited how much candidates could spend on their campaigns and how much support they could get from their adherents. They limited how much independent groups could spend to speak about candidates, and they imposed broad, burdensome disclosure requirements on anyone who spoke publicly about political or electoral issues. And they enacted a new, broader, and more burdensome disclosure regime targeting nonpartisan issue groups that put out public information about political candidates. The law provided for the first time public funding for presidential candidates, but structured to favor the two major parties and to disfavor insurgent candidates. The final First Amendment insult was that to enforce all of this, the law created a powerful new agency, the Federal Election Commission, the majority of whose members were appointed by the members of Congress, like letting the fox guard the chicken coop. Most people thought these new reforms would solve all the problems of money in politics, but we thought that the law's severe restrictions on campaign spending and giving violated core First Amendment protections of free speech as the engine of democracy, and that the law was both a First Amendment disaster and an Incumbents Protection Act to boot. So we organized a strange bedfellows coalition to challenge these restrictions. It was led by Senator James L. Buckley, a conservative Republican, and Senator Eugene McCarthy, a liberal Democrat. Other members of the Hardy Band included the Mississippi Republican Party, the New York Civil Liberties Union, and other groups and individuals across the political spectrum. The two senators were perfect poster people. for the harms to democracy the law would cause. They had each achieved stunning political success by raising large contributions of seed money, now prohibited by law, and spending what they raised to communicate their message. Both senators could not have accomplished these feats under the new law. We filed the lawsuit in January 1975 when the law went into effect. Because of its importance, the suit was heard by the United States Court of Appeals for the District of Columbia Circuit in an en banc proceeding. But the tenor of most of the judge's questions was quite skeptical of the challenger's argument, and most seemed to defer to the claimed government need for restrictions. We received, shall we say, a hostile audience reception. Representing the ACLU position, I argued that the disclosure provisions as to parties and candidates were too wide and deep. It was ridiculous to think that anyone could buy a member of Congress for an annual $110 contribution. It was also ridiculous to think that you needed to have full disclosure of the tiniest political funding by groups like the Socialist Workers' Party. As to the new burdensome disclosure provisions against nonpartisan groups like the ACLU, we said they undermined First Amendment requirement of fullest debate on politics from a wide range of sources. When the case was decided, an appeals court upheld all the major new provisions of the law except one. The provision targeting disclosure by groups like the ACLU was struck down unanimously as a violation of speech and association. So the battle finally moved to the Supreme Court. Because of the vital national significance of the case, the court set aside an entire day for argument with all the earmarks of a major national event. Our legal team included Ralph Winter, a Yale Law School professor who would later become a highly respected Second Circuit judge, who argued against the contribution and expenditure limits. I argued the case against the overbroad disclosure imposed on major parties and candidates and independent groups. Bryce McAdoo-Claggett, a top-flight litigator at Covington and Burling, took on the public financing and the FEC. And we were all helped enormously by a bright young Covington firm associate whom you might have heard of later, named John Bolton. On all of the issues of the case throughout the day, and for the first time, we felt we were finally getting a fair hearing on our claims, that the court was finally taking our arguments seriously and questioning the government's arguments just as seriously, and that maybe, just maybe, we had a chance to prevail. When the decision came down, it was a split decision, a bit like a Goldilocks approach, if not a Solomonic one. Spending limits bad, contribution limits good. Disclosure good, but not for independent speech unless there's express advocacy for a candidate's election or defeat, or for the controversial minor parties like the Socialist Workers' Party. That latter point resulted in a huge 1982 Supreme Court victory in Brown versus Socialist Workers 74 Campaign Committee, which the ACLU handled. The court upheld the public financing system, despite our arguments that it was wrong to have government finance election campaigns, which were designed to test and challenge the government. But the court struck down the method of appointment of the federal election commissioners on the grounds that the strict constitutional appointment process had not been scrupulously followed. The core of the opinion was the striking down of campaign and political spending. These really cut to the heart of the First Amendment, and most jeopardized the crucial combination of freedom rights enshrined in the First Amendment. Two principles were particularly clear. First, the court said there could be no leveling of political speech to equalize voices. Quote, the concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment, which was designed to secure the widest possible dissemination of information from diverse and antagonistic sources, and to assure the unfettered interchange of ideas for the bringing about of political and social change desired by the people. Close quote. Second, and equally important, the government cannot have the power to control the quality of political speech. Again from Buckley, quote, the First Amendment denies government the power to determine that spending to promote one's political views is wasteful, excessive, or unwise. In a free society ordained by our Constitution, it is not the government, but the people individually as citizens and candidates, and collectively as associations and political committees, who must retain control over the quantity and range of public debate on public issues in a political campaign, close quote. In Buckley's landmark ruling, for the first time, the Supreme Court held that campaign limits violated First Amendment rights. It was a strong victory for freedom of speech and association, but it was not a total victory. While the court struck down limits on political expenditures as unjustified restraints on core First Amendment values, it upheld limitations on contributions to candidates because of the concern that they might lead to corruption or the appearance of corruption. That split judicial decision would lead to many of the problems that have affected campaign finance system for the 5 decades since. For the past 50 years, Buckley has provided the constitutional framework governing the financing of our politics and the platform for a more recent Citizens United case. The core principle is that the people, not the government, get to decide how much political spending they want and need in order to challenge the government. Here are the major takeaways from those 5 decades. First, the divide between contributions and expenditures has remained, resulting in a distortion of our campaign financing to the detriment of less wealthy candidates, a pushing of funding away from parties and candidates and toward outside sources, and separating the parties and candidates from each other. Second, the effort to deal with some of these problems with the 2002 Bipartisan Campaign Reform Act, so-called McCain-Feingold bill, was an unmitigated disaster. Challenged in a lawsuit organized by Senator Mitch McConnell, and also including as plaintiffs the Republican Party, the AFL-CIO, the U.S. Chamber of Commerce, and the ACLU, the law was upheld by the Supreme Court 5-4, capping a short 3-year period when the court was at the nadir of handling the clash between First Amendment rights and campaign finance restrictions and controls. Third, things have changed appreciably in the 20 years of the Roberts Court era. First Amendment rights have been more protected than ever before. This includes 7 cases in a row in which challengers have run the table with the court striking down campaign finance restrictions in a major constitutional course correction. And hopefully an 8th case is in the wings in a Republican National Senatorial Committee case, which we're expecting any day now. Fourth, the 2 pillars of Buckley, no limits on political speech and no leveling of speech, have remained firm. The Citizens United case applied the first principle, and a recent unanimous decision reaffirmed Buckley's rejection of leveling speech to rectify economic disparities. The part of Buckley was roundly condemned at the time as the product of an elitist court favoring the rich and undermining our democracy. So I felt some schadenfreude, delight in the court's 9-0 decision in Moody v. Net Choice in 2024 that states could not compel social media platforms to include speakers they did not want in order to provide viewpoint balance. The court did so relying explicitly on Buckley for its principle that government may not, quote, restrict the speech of some elements of our society in order to enhance the relative voice of others, close quote. And the author of that opinion was none other than Justice Elena Kagan. Buckley v. Valeo, welcome to the First Amendment canon. So, what does the future hold? It is gratifying after all these years to see that the core victory we achieved in the Buckley case has withstood the test of time, and that Citizens United, used as a bogeyman and punching bag for so long, has also gained some welcome respect. But 2 things remain on the unfinished business list of the strange Bedfellows Coalition of 1976. First, the unjustified treatment of political contributions as second-hand speech. That was the phrase actually used in Buckley. Always struck me as a make-weight. Happily, the Roberts Court has chipped away at Buckley's upholding of low contribution limits. Hopefully, the current NRSC case involving the right of political parties to use funds in cooperation with the candidates they support will continue the pattern of skepticism and constitutional invalidation. Which brings me finally to disclosure. This is where I came in quality for me. I was the lawyer who argued against disclosure in Buckley, and we won some major victories. The Circuit Court unanimously invalidated the special disclosure provision, which targeted issue groups like the ACLU, and the Supreme Court narrowed disclosure to apply only to those messages by independent groups and individuals which expressly advocated the election or defeat of a candidate. Equally important, the court fashioned a so-called Socialist Workers' Party exemption, which mandated respect for the rights of speech and association of highly controversial groups whose members should be free from disclosure. But finally, the one disclosure loss that has always been a shame was the incredibly low threshold of contributions that the court said had to be revealed. In Buckley, it was any contribution in excess of $100 in a calendar year, raised later to the paltry sum of $200. A threshold that the court said was, quote, indeed low, close quote. But the court allowed it and deferred to congressional line drawing. To borrow a phrase from a well-known, phrase about obscenity, I may not be able to define corruption caused by campaign contributions, but I know it when I see it. And I assure you, $225 from yours truly to my Senator Chuck Schumer is not going to make him take my call. As a result of the Supreme Court's default on this issue at the federal, state, and local levels, tens of millions of small donor contributors have had their political and associational privacy invaded by burdensome and wholly unnecessary disclosure requirements. And today, by a few keystrokes on a laptop or a cell phone, one can look this up, and it is difficult to imagine an important, let alone compelling purpose served by that massive breach of political privacy and freedom. To my mind, the only purpose served is a form of political voyeurism. In conclusion, the litigation efforts that began in the summer of 1972 continued through January 30th, 1976, and have strengthened in the decades since then, and have been essential to safeguard free political speech and association, and thereby to safeguard democracy. It has been my honor to have been associated with those efforts, and I wish the best to all those who will carry on the battle for free speech and democracy in the years to come. Those conclude Joel's remarks. And I would just say for myself, it's such a pleasure to see you all here, and it's such an honor for me to be able to pinch hit for Joel. It's unfortunate that we didn't have him here, but I'm sure we appreciated hearing his sentiments. Thank you.
Well, I feel like Professor Gore was with us. Let me briefly introduce our moderator as our panelists take the stage. Lindsay Specht is of counsel at Dickinson Wright here in Washington. Her practice focuses on government affairs and political law. Lindsay previously worked in both government and nonprofit legal roles, including at the Federal Election Commission and Stand Together and Americans for Prosperity. She's a graduate of Monmouth University and the Catholic University's Columbus School of Law. As I hand things off, a reminder to our audience that we will have ample time for Q&A at the end of the panel, so please start thinking about your questions now. Also, please ensure that you ask a question. We would be happy to invite you to give a speech at another time. With that, Lindsay, please take it away.
Thank you. It is my great pleasure to introduce our panelists today as we recognize the importance of Buckley v. Valeo and discuss the enormous impact this case has had on American political discourse and participation for the past 50 years. We'll discuss where we currently are and where campaign finance regulation might be headed in the next 50 years. Alan Dickerson is former chairman of the Federal Election Commission, a seasoned appellate litigator, and presently a partner at Baker Hostetler. At the FEC, Commissioner Dickerson worked to restore function, leading the first bipartisan adoption of a regulation in over a decade and reform of the Commission's investigations and interagency practices. Prior to his tenure at the Commission, Alan spent nearly a decade representing organizations across the political spectrum in First Amendment challenges to state and federal laws governing civil society before federal appellate and state Supreme Courts and regulatory agencies as legal director of the Institute for Free Speech. Alan serves as the Federalist Society Election Law Practice Group Chairman. Next, Mr. Adav Nodi. Adav Nodi serves as Campaign Legal Center's Executive Director, where he coordinates all of CLC's operations and programmatic activities and oversees CLC's efforts to protect elections, fix the campaign finance system, and promote government ethics. He has conducted dozens of constitutional cases in trial and appellate courts in the U.S. Supreme Court and advises lawmakers on policymaking and legislation. He regularly provides expert analysis for TV, radio, and print journalism. Adav previously served as CLC's Chief of Staff and Legal Director, and his knowledge and experience in campaign finance law is as varied as it is deep. Prior to CLC, he served for more than a decade within the Office of General Counsel at the Federal Election Commission as Associate General Counsel for Policy and Acting Assistant General Counsel, and before that, as an AUSA for the District of Columbia. And Elizabeth delivered my introduction for Mr. Brad Smith down there as well. So each of the panelists will have a little bit of time to give introductory remarks, and then we'll jump into some questions.
So it's always, so all of us in this space stand on the shoulders of giants, but part of the deal is that you don't see the giants. It's a little bit awkward here because to have Joel Gora give remarks through Brad Smith, I feel like you can see my little legs kind of dangling there on the giant's shoulders. So this is a very special day for me, and I'm very grateful for all of you who have attended here and to my panelists for joining. It's also an exciting and rare event. It's not often that a case survives for 50 years as the preeminent authority in an area of law. The Buckley Court encountered a deeply flawed law, and rewrote nearly every substantive provision of that act. In the process, it created most of the important concepts in campaign finance law: the major purpose test, express advocacy versus issue speech, disclaimers, disclosure, the list goes on. For any of you who don't practice in this area, please just take my word for it. The very vocabulary of campaign finance law was created in Buckley. That's one sort of immortality. But I think the fact of Buckley's longevity is in many ways less interesting than the reasons for it. After all, why of all cases did this lengthy, complex decision stand the test of time? And it's surprising if you think about it. The Buckley court had everything arrayed against it. The national mood immediately following Watergate was not exactly conducive to sober decision-making. The court had to act very quickly and address a massive piece of legislation. It wrote its 140-odd page opinion in a little over 2 months, and it did it at a time when it was deciding more than 170 cases a term, which is more than double what the court takes now. And it did it with only a single noted dissent. You add to that the fact the opinion itself is complex. It lacks any of the rhetorical flourishes that endears Supreme Court opinions to the general public. And you do have to ask why this case, in particular, is the one that survived. I think one reason, and the one that most people agree on, is that it reflects a sober and near unanimous compromise, which Professor Gora explained for all of you, which saves me some time. In exchange for limiting the most dangerous forms of political spending, the direct contribution of funds to candidates, which, I hasten to note, at the time could be directly pocketed by those candidates, the court limited the ability of the government to bar or regulate the actual spending of money on speech. I think there's merit to the view that the Buckley survived as a compromise, but it's not my own opinion. In my view, Buckley survived mostly because of its clarity, not as compromise. The court correctly understood the stakes. The rhetoric surrounding campaign finance law tends to be about the outsized influence of the wealthy and similar tropes. But the actual law as written limited spending to $1,000, not $1 million. It set its disclosure standard at $100, not $10,000. And it purported to regulate and either limit or ban any public discussion, quote, relative to, end quote, a candidate, including an incumbent office holder. That statutory scheme would have snuffed out all independent organization around political speech in this country. It would have provided a monopoly to the major political parties and to the press, and indeed it was designed to do precisely that. It would have kneecapped what the court called effective advocacy. I think the Buckley Court's wisdom lies in response to that test. I just want to highlight 2 things from the opinion. The central problem in political law has always been what is political. And some of you have heard this lecture at various law schools, so I apologize. The central problem has always been what is in and what is out. Because in a self-governing republic, everything affects elections. I used to joke that if you really want to affect the elections, change the unemployment rate by 2 points. That's the sort of thing that drives voting in this country. And in a free society, it is going to be impossible, as the Buckley Court recognized, to disentangle discussions of issues, discussions of how we actually want to run this country, from discussions of candidates and who should be elected in given elections. That's an impossible task. And so the court said, we're going to be very clear about what's in and out, because the real danger here is vagueness. And so it said, we're going to talk about 2 things. 1, the only organizations we're going to regulate are organizations controlled by candidates or organizations whose major purpose is electing candidates. That's what's in, and everything else is out. And 2, when we talk about the sort of speech that's going to trigger our regulations, it's going to be speech that expressly advocates with magic words, a vote for or vote against, the election or defeat of a candidate. And I mention this because many people of goodwill and smart people have found that a very unsatisfying result. But I think that clarity, that willingness to draw the hard lines and say this is in and this is out, to provide ordinary people who do not spend all day, like some of us in this room, parsing out these incredibly complicated tests for these things, Giving them the certainty of what is and isn't regulated is the core liberty maximizing insight of the Buckley decision. And in my view, the great threat of campaign finance regulation has always been that the flood would burst the banks and carry away an independent civil society. The Buckley court gave us the tools to resist that flood, and at least in my view, that's the foundation of its enduring legacy. Thanks.
Great, thank you all for the chance to be here today. I have had the pleasure over the years of exchanging views with all of my co-panelists on these issues many times, and it's a real privilege to be able to do that again today. For this sort of brief opening segment, I'd like to try to narrow what I think are the perceptions of the fault lines around Buckley, try to clarify what I think is and is not actually controversial about the opinion. So, because I think the actual disagreement is in many ways both simpler and more fundamental than often gets presented. So one thing that I think is not seriously in dispute is sometimes gets phrased as, money isn't speech. And I recognize that that is a slogan used in political context, but I would suggest that in the legal context, at least, no one seriously disputes that spending money to promote First Amendment protected speech can itself be First Amendment protected. Of course it can, and you can think of infinite examples of that. One that gets used a lot is, freedom of speech wouldn't mean very much if you say, well, freedom of the press wouldn't mean very much if, the press can publish whatever it wants, it just can't spend any money to do that, right? That would make a mockery of the First Amendment. And so I think the recognition in Buckley that spending money on campaign speech can be First Amendment protected is really not that controversial. The other thing that I think is not that controversial ultimately, and actually Professor Gore's remarks and Alan have already mentioned this, is the expenditure contribution divide. It is, I agree with many, maybe even most folks who think about these issues that is not a very intellectually satisfying line, that if you think about it too hard, it does tend to break down, but that's okay. It was a compromise. It was an obvious judicial compromise coming from a court that, I think the Goldilocks was a phrase used, it was a court that recognized coming out of Watergate that something needed to be done about the corrupting effect of money in elections and politics, but not to the point of squashing First Amendment rights. And that was the compromise that was struck. And I don't think that in and of itself has presented issues. I think that it is more of a symptom of what I perceive to be the real underlying controversy around Buckley, which I think is this. Buckley framed the entire constitutional question as the First Amendment rights of speakers, on the one hand, spenders on political speech, versus governmental interests. And that framing, that sort of balance striking, is completely apples and oranges. Those two things are very, very different from each other, and trying to weigh them is an incredibly subjective exercise. Completely subjective, how to balance these two totally different things. And because it's so subjective and because it's so mushy, what we have gotten for the last 50 years tends to be judicial opinions that tend to reflect the political views of the judges who are issuing them in this area because of this subjective standard. And that's not great. That's not great for the law. That's not great for perceptions of judicial legitimacy. I think what would have been better would have been for the constitutional question to be teed up as the First Amendment rights of major political spenders versus the First Amendment rights of everybody else, everybody who wants to engage in political speech but can't do that through major spending. That is an apples to apples comparison, right? Where does one person's or one entity's or one corporation's very significant political spending begin to infringe on the political and First Amendment interests of other players in the system? For 40 years, we really didn't have that conversation happening. It has started happening now. It was a pretty significant focus of the dissenting opinion in the Supreme Court's McCutcheon case, and we've seen it more entered into the sort of judicial discourse. I think it will eventually become the frame that gets used because the current frame is pretty unsatisfying. But because of Buckley, that is the frame that we currently have, and I think that has been the underlying cause of a lot of the disputes.
All right, well, thank you all for attending. Thank you, Melody, for handling us up here, and Alan for organizing things, and thank you, Ada. It's always a tough role. I've played it many times, and it makes for a much better event, I think, for those in the audience, and actually for those up here on the panel, too, to have that different look at things. So I want to just reemphasize a couple of things that were implicit, in some respects explicit, in Joel's remarks and in Alan's remarks, and that is what we are looking at, or might be looking at, had the court not ruled the way it did in Buckley. In other words, why is Buckley historically significant? Now, my good friend John Sample says, well, if it hadn't been Buckley, we would have had to have another case reach these results for reasons I'll touch on. But I said, but it's Buckley is the one that did it, and it did it right away, and thus had minimal damage. To think about this is to think about the difficulties of taking broad principles. You know, people don't like money in politics. They feel like they're unequal, and that sort of thing. And those are true, and those are real concerns, and they've existed throughout American history. On the other hand, how do you write these into law? Who's going to write it into law? And what do you get at the end of the day when these people have written it into the law? And with that in mind, it's worth really focusing in on what the Federal Election Campaign Act did before Buckley. It limited a group, an organization, Planned Parenthood, Right to Life, the NRA, Everytown USA, the Chamber of Commerce, the Environmental Defense Fund, the NAACP, the ACLU, you name it, was limited to spending $1,000, quote, relative to a candidate for office. That's nothing. I mean, today that gets you like a 2-inch, 1-column ad in the New York Times, okay? And that's all that a group like that these groups that represent millions of Americans, represent every segment of our society, could spend to talk about candidates. Moreover, the candidates themselves weren't given a lot of money. The candidates were limited to, in for example, U.S. House race, $70,000, which even in 1974 was far less than challengers had to spend to unseat incumbents, far less than people would spend in tough races. So you had a system where we would say, how are people going to find out about candidates? What's a campaign going to be? Well, there was one group that was exempt, and that was the institutional media, the institutional press. They were exempt from this because, as all of us who have been around for a long time know, the institutional press is never biased or losing objectivity in its coverage of events, right? That's it. Our politics would have become, essentially sort of a non-politics in which you don't talk about public affairs. Because again, note that term relative to. That was the whole theory of the Nixon administration in the case that Joel describes in his remarks, the Committee on Impeachment case. Well, if you want to impeach the president, that certainly could affect his election results. It's relative to him, bam, and you could be limited under the rules that came up in the 1974 Act. This is what you're going to get. You have to be serious about the realities of power and the legislative process and so on. And I think when you are, we find ourselves saying, I get it. That's why we have a First Amendment, isn't it? It's precisely to protect us from that kind of law, that disastrous scenario. It's not because we really think it's just great if Elon Musk can spend another $1,000 right, on top of the 200 billion or whatever he might have spent, or 200 million he might have spent, right? That's not what it's there for. It's there because we know that the reality is not going to be puppies and roses and balloons, okay? It's not going to be quite so nice. And we have to think further about what that would have entailed, because it was written at a time when most cities had one or possibly two major daily newspapers, two or possibly three networks, and maybe one independent station, often an independent station that was run by the government, the fledgling baby of PBS. And we'd have to ask ourselves, you know, how would people communicate? Well, people would communicate by starting to buy newspapers, create alternative types of press. And especially in this day and age, when you have the internet and so on, people can get into this. But then somebody's going to have to decide, who is this press? Because otherwise, you're back to square one. Anybody can spend anything they want if you don't decide what the press is. In fact, that was inherent even in the law as it was first passed, because the law says that you're exempt if you're publishing things in a periodical, right, or broadcast ad. Well, what's a 30-second campaign ad but a broadcast, right? That's broadcast. But we immediately said, well, no, that's not press. You don't become press because you pay for ads. You have to kind of own the press. But what happens when you can create DVDs at home, when you can put videos up on YouTube, when you can create blogs and newspapers that exist solely online at very low infrastructure cost? Inevitably, we would have had to have a licensing program for the press, or we would have had to chuck the whole system again. It simply can't work. So this is the roots of what we have. And I think, therefore, when Buckley suggests that that there's no room for equality here, that it's not for the government to decide who's spoken too much and who's not spoken enough, it is right on target. That's exactly what the First Amendment is intended to do. The First Amendment doesn't say the current mix of spending that we get is just right. Right? It takes the exact opposite approach. We don't know what that mix should be, and again, that's sort of up to the people to determine. And to frame that right, as Adav would do, as between those who want to speak and everybody else, just seems to me utterly bizarre, because people don't pick your pocket, they don't harm you, they don't take anything from you. And empirically, the idea that certain voices are quote, drown out, or that somehow public discourse should measure pre-existing opinion rather than be used to try to change opinion, strikes me as wholeheartedly wrong under the First Amendment. So I think when we think about what our politics would look like without Buckley, and this is what we need to think about when people come today and say we need these restrictions. We think about how this is really going to look. We have to conclude that it's not an exaggeration to say that Buckley v. Valeo is the case that saved American democracy. A democracy where no group of people, let alone one person, but no group of people can spend over $1,000 to talk about things, quote, relative to their government and its office holders, is not a democracy at all. And that's the real historical significance of Buckley, and why we're pleased to be here today to pay a little tribute to it. Thank you.
Thank you, all of you, for those deep and insightful remarks. I'm going to start off with a few questions, but panelists feel free to answer directly, respond to one another. I want this to be very conversational. It seems among the panel that there's little disagreement that Buckley standing for spending money in political speech is constitutionally protected, right? But Buckley also makes clear that spending money in this way can be limited to prevent corruption, the appearance of corruption. Have the contribution limits upheld by Buckley worked? Has Buckley sufficiently diluted the ability for any single person to disproportionately influence a candidate or lawmaker? Does FECA work for the purposes that it was intended to design?
All right,
Whoever's ready.
I'll let Brad correct me on the back end. So you can think of this in a bunch of different ways. I started my career as a white-collar guy in New York, so I sometimes just think of this in economic terms, which is unusual in this space where it's all about rights. You know, one of the things that FECA got wrong, you know, and to address Adav's point about kind of First Amendment interests on both sides, I mean, I think the reason we talk about governmental interests is that we presume that the government is speaking with the voice of the people, and so it's kind of double counting to assume that, no, the majority gets to set the government policy, but they also have these separate interests that go into the constitutional analysis. I think that Buckley, did adequately convey public opinion at the time it was passed. The problem was that the way they wanted to do it was by essentially setting price controls on political speech. You couldn't have, so much spent by candidates or by outside parties or whatever else, and if you just managed to set the price of political speech as something you're comfortable with, then the whole system's going to work. In their defense, we were doing that with whole buckets, we had whole buckets of commodities we were doing with in the 70s. It didn't work. What happens when you do that is you end up with black markets. This has been economic insight for 200 years. There's nothing magical about speech that changes the central, demand and supply curves that we're dealing with. So in that sense, I'm not so certain that taking the additional step of saying, no, the candidates can spend as much as they wish, subject to these limited inputs, really changes the overall dynamic of we're trying to set a price control because there's too much speech being given by the wrong people. And so personally, I'm kind of skeptical that the contribution limits have really accomplished their goals. Not in the sense that they're too high and people are getting corrupted. I don't think that's the issue. I think the issue is by imposing these contribution limits, which by definition mean people are giving less than they otherwise would give, you're forcing that speech into other channels. And we've spent 40 years being very angry about that fact and passing increasingly intricate and Byzantine laws to try to get around quote unquote loopholes. But it's all downhill from that, it's all downstream from that initial decision by Buckley. And so, no, I count me as a skeptic that it is structured, that is worked as intended, both in Buckley in itself and also in the original FICA.
No, Brad?
I will not say much except for, two things. One is the way the question was framed, I want to speak so that Adolf doesn't have to use his time to say this, which is he doesn't have to defend the actual act, has it worked exactly as it's planned, to defend the principles on which regulation is formed. So this may just be a bad use of those principles. But I do think one of the key things that's done by dividing contributions from expenditures, just to elaborate on what Alan said, you realize what that means. In other words, we've constricted supply and not constricted demand, and that emphasizes that shortage and thus the subterfuge, the working arounds that Alan talked about.
Right, and I think the economic metaphor or comparison works. But I guess I would differ on sort of what has caused the breakdown in that market. I don't think it was Buckley upholding contribution limits. If that's all that had happened in the last 50 years, we might be relatively happy with our system. What's happened, though, is that there have been a number of Supreme Court-driven modifications post-Buckley to that system. Each of those modifications has opened up different avenues for that demand to be met in problematic ways. Congress has responded, and the Supreme Court has blown open more holes in those responses. And so the end result, I think, the system we have today is highly ineffective. Money is coming in ways that are at least as corrupting, if not more, than what Buckley upheld Congress's ability to regulate. But I would not ascribe that to Buckley's upholding of contribution limits. I would ascribe that mostly to subsequent Supreme Court decisions that have opened up all these other channels.
Either of the other panelists have a response to that? How do we measure what is corrupting? Is it based on the public's view of their government and their representatives? Is it based on just the sheer amount of money that's floating through the political system now?
Well, I would say it's very difficult, and one of the real weaknesses of the Buckley opinion is this notion of the appearance of corruption. I'm not sure I'm not sure the weakness is not from the way people have interpreted it, which may not have been what the court intended. But we talk about the appearance of corruption being a sufficient government rationale to enable these constraints. We don't do that elsewhere. We do not say, well, let's do away these Fourth, Fifth, and Sixth Amendments because people are concerned about the appearance of crime. And we know from empirical data that this matters, that when people are afraid that there's a lot of crime, people stay off the streets, and then the streets become more controlled by criminals, and there is a sort of a build-up process there. We could easily go in that direction. Generally speaking, on our rights otherwise, we don't use public appearance as a basis for restricting those rights, what people think that may be an error. That just leads us back to the question of, well, how do you measure what is corrupt? And what the court has increasingly focused on is some type of quid pro quo exchange. It may fall short of bribery. And sometimes it's hard to say, what's the difference between bribery and a campaign contribution? People I hear say it looks the same thing, right? Legalize bribery. But here's the thing. Every democracy in the world that I know of allows campaign contributions and prohibits bribes. So somewhere we know that there is a difference. I suggest that big difference is the ability to use things for personal use, to buy yourself things that you would otherwise have to spend your own money on that you don't need simply for the purpose of campaigning, like hiring a campaign manager or running an ad saying vote for me, or paying for a hall to have a rally, or whatever you have. And within that, the court says essentially, if it's not a sort of quid pro quo exchange, I will give you this contribution on the condition you take some official act for me. The court is increasingly willing to say that it's okay, that ingratiation, access to politicians is not corruption, because politicians have to limit their access in some way. They can't just take all comers. They don't have 24 hours a day either. Of course, they're going to give more time to people who have supported them in different ways, including entertainers and news broadcasters and people like that. And of course, you want people to be grateful for what you've done, and you're grateful for what people do for you. And if we start defining those things as corruption, I think, again, our entire democratic process kind of grinds to a halt. What would it mean to say that we should all have equal political influence? It would mean none of us have any political influence, which means none of us have any incentive to be involved in public life because we can't do anything about it. I mean, if you're really serious about that concept, now one can say, well, we don't need to go that far, we just want to cut it off at the extremes. But then you're back a little bit again to the problem of saying, can we trust the office holders to do that? Or do we count on the courts to just be constantly stepping in and saying, well, this is too far, this is not too far? Which is, by the way, what they did in Buckley. They said, well, we can't really probe whether a $100 donation limit's too high or too low, or a $1,000 contribution limit's too high or too low. So they just let it all go on some of these things, and that was very problematic. So that's a long way of saying, I have no idea how you're supposed to measure corruption outside of that kind of quid pro quo exchange that may fall short of bribery because it's not for the personal use of the candidate. And I think, I think that kind of exchange is exceedingly rare in politics, actually.
Yeah, I mean, I think there's two ways you can go about assessing the corruptive effect of money in politics. One is look at the current system and just assess. I mean, we're all, this is by definition, this is a room of DC insiders, right? A lot of us work on with members of Congress all the time. Are members of Congress acting in the interests of their constituents or their donors? If the answer is really ever the latter, that is corruption by definition. Those are not the people who are voting those people into office. The entities or individuals who are financing super PACs and other entities are not the constituents. And so if elected officials are acting in those entities' interests, that is corrupt. That is certainly happening, and whether it's in the form of taking meetings or actual legislative action, I don't think we can seriously dispute that that's happening. The flip side way to look at it, I think, is look at the states that have transitioned to public financing models, effective public financing models, and look what happens in their legislatures. And the record is very impressive that when you give legislators a way to get elected without having to go to major donors, they are much more reflective of the public will. They are much more likely to take legislative actions that their constituents want them to take. And it's much harder for quote-unquote special interests to obstruct that process. And by special interest, I just mean, money coming in from folks who are not constituents. So I think either way, you can look at it either way, and it probably, you get to the same result with regard to the current system.
So unsurprisingly, I think it's a little more complicated than that. In a few ways. I mean, one is, I think it's kind of a false dichotomy to say that, either you're working for the benefit of your constituents or you're working for the benefit of your donors. There's oftentimes a lot of agreement between your constituents and your donors. How do you disentangle those variables? That's tough. I think there are reasons to doubt this happens as often as people claim it does, because we have trials in this country. There are challenges to campaign finance laws, and in every one of those trials, the state is asked, put up your evidence that there's all this corruption happening. And somehow, miraculously, there are never experts who come in and say this stuff that are accredited by the courts. One of my favorite experiences as an FEC commissioner was sitting watching one of the cases in the Supreme Court. And when both the Chief Justice and Justice Kagan are laughing at your evidentiary record, you're having a bad day. So I do think there are reasons to doubt the sort of obviousness of this, because when we actually try these questions, the evidence somehow doesn't materialize. And I do think people like Adav kind of, have tried to carry that burden in court, and it just kind of hasn't worked. So I'm skeptical on that as well. I think finally, some of this comes back to a theory of government. And I guess I'm kind of old-fashioned in thinking that there is not necessarily a one-to-one relationship between what the average man in the street thinks should happen and what a responsible representative, should do on behalf of his or her constituents in every case and in every detail. I won't burden you all with the speech at Bristol, but there's a long tradition of doubting whether or not a representative should be just slavishly, channeling the public will. I'm not really a Rousseauian. I don't think that's how any of this works. So that's, I think, another part of this is that, you've got these incredibly complicated causal questions. Every time they're actually put to the test in court, folks come up empty. And I think that's just because fundamentally the country is a lot less corrupt than people, when in their anger about how complicated life is, kind of feel about it. And most representatives are doing their best to deliver the things they think their constituents need. That most donors are supporting people who they think will do a good job in the direction of what they're doing and not trying to, lead them off the correct path. I think a lot of these narratives just don't work as a matter of governing theory, and so the metaphors kind of fall apart in practical application.
I want to add just a little more on a couple points. One is, as Alan says, somebody's going to have to decide whether you're really representing your voters or whether you're really representing somebody else. And what's it mean, as Alan says, to really represent your voters? Burke would say it's to do what's in their best interest, not to do exactly what they want at the time. That's why you're elected representative and have the time to study these issues and think about it, right? That's why we don't have direct democracy, is that the ordinary man on the street, he knows, he might know generally, I think we need to do more to clean up the environment, and he'll vote for candidates who promise to do that. He cannot tell you within $100 billion what the budget is for the Environmental Protection Agency, and so people need to have that. The other point is that when we talk about state, that have adopted public funding, I think New York City with its public funding program is clearly a model in good governance, and I think that that's a laugh line. But and I think when we look at this, for years, the Pew Charitable Trust, which was a big funder of campaign finance reform restrictions, they used to fund these organizations to millions and millions of dollars, right? Because money in politics, they didn't care if it was their money, right? So they're spending millions of dollars to fund this. But they had another hand, that's their right hand. And over here they got the left hand that's doing an index of good state governance. And every year they do this, they do about every other year. And every time they did this, the best governed states were inexorably the states that had the lightest campaign finance regulations, that had the loosest regulations, the states often that had no limits on contributions whatsoever, were the best governed states. We used to look forward to this at the Institute for Free Speech because we knew it was going to be a great propaganda day whenever the Pew report came out. And I like to think, although I don't know, that that's one reason Pew quit doing the report, because every time they'd release it, we'd jump on it and point out how all the unregulated states had the best government results. And so I think that's, you know, again, why do we have democracy at all? It's really to try to get good government, and you get good government by filtering things through responsible representatives who can, because they have more time to give it more thought and do more, can say to their constituents, I know that sounds good, but that's not quite the way it works, or that's not a good idea, or we can do that better, or whatever it may be.
Anyone have a response?
I mean, of course we elect people into office to do more than just tally up the views of their constituents and do that thing, right? Of course we elect people to use their own judgment. The question is, what factors are they weighing in exercising that judgment? And if one of the factors they are weighing is, what does this corporation who has no presence in my district, no employees in my district, nothing whatsoever to do with my people, but they care a lot about the work of this congressional committee I sit on, if I am factoring in what that corporation is going to do, and I am weighing that in my legislative decisions, that is corruption. That is literal corruption. That is a corrupting of the representative process. That happens every single day in Washington. It happens in many states. And that is not in any way in tension with the idea that we want legislators to exercise their own judgment.
So Buckley, in addition to upholding contribution limits, strikes down limits on expenditures as a direct limit on the amount of speech someone can engage in. Nadav, you've mentioned, there may be some tension and intellectual honesty here between those. Happy to discuss that. But I do want to get into a little bit on what sort of expenditures, what sort of speech does Buckley allow us to regulate? Alan, you've talked about the magic words, the Buckley standard. Is that something that has been consistent throughout the case law? Is that an approach that the court has kept with? Has it expanded? Has it contracted? Where should we be landing?
So, I mean, this may be an unpopular view. I used to tell the lawyers at my old agency, like, the original sin of campaign finance law is not overbreadth, it's vagueness. Like the real dagger at the heart of civil society is the unclear definition, or the redefinition of terms, or the oversimplification of complex systems into a soundbite. Like, that's the stuff that's dangerous. And I think Buckley really understood that. And so, no, we're no longer in the world where, it's express advocacy. Now there's this concept of what's the functional equivalent of express advocacy. And I have sat in all three of us have sat in a lot of meetings with people of good faith who do not agree on what the substantive, what the actual functional equivalent of express advocacy is. That is a test that is not susceptible to clear and mechanical application. It's a word, like corruption, that does not have a literal meaning that you can just sort of like bludgeon people with. Like, it's a very complicated concept, and it is almost impossible to enforce. And the danger, the really deadly danger in a test like that is that people of goodwill come to these conversations with their own biases and worldviews and whatever else. And the functional equivalent of express advocacy in edge cases, it is going to take real care and a very strong moral compass for those preconceived notions not to enter into the analysis sneakily. So I think we have moved into wider areas of speech that are regulated. I understand why we did that. I mean, certainly, the Buckley court had its eyes open that when it said you have to say vote for or vote against, it was inviting the risk of people coming up to the line. This was not a naive decision. This was a principled decision to say, if I have to choose the risk of subjective enforcement and a test that ordinary Americans can't understand when engaging in core political speech, or have to accept the risk that an ad is going to get a little too close to the line and go unregulated, the First Amendment compels, and the court agreed, that the latter risk was the one to be accepted, right? Like we should accept a clear line, even if it isn't drawn in precisely the right place. That's my view. I think that was Buckley's view. I think it's increasingly the Supreme Court's view. But it's a very hard thing to explain to people that no, in a republic that spans a continent with 1/3 of a billion people, the level of sort of just statistical risk you have to take systemically is quite high. And efforts to sort of constantly chase that last 1% or that last loophole, end up with these rules that no one can understand. And so we have expanded beyond the Buckley, test. I think that was a mistake, at least insofar as we've expanded into these tests that no one can consistently apply.
I mean, on the question of should we have sort of spending limits, I think the idea of like a European-style rules where we just have like a 3-week campaign and it's limited and you can't do it before, you can't do it after, I don't think that could ever be done consistent with the First Amendment, right? I think we have to accept that in our constitutional framework, there is going to be it is very, very difficult to limit on the demand side. And so if we're going to get at corruption issues and we're going to get at ensuring that no one spender or set of spenders can drown out everybody else, it needs to be on the supply side. And then I think the question becomes, as Alan was alluding to, how do you distinguish between those? And I think a lot of the problem that we have right now is that the rules that we have that distinguish between what is supply side contribution and what is demand side spending don't make any rational sense. And a lot of what is nominally right now spending sure looks a lot like a contribution. And that's because of court decisions, that's because of FEC decisions, that's because of a lot of things. That's not because of Buckley per se. I think the rule laid out in Buckley is, as we've all said, a sensible compromise. It's subsequent developments that have led to its breakdown.
This is a follow-up for you, Adav, as the maybe minority on the panel on this issue. But to Alan's point about magic words, about express advocacy, and you've talked a lot about broader influence in elections, independent spenders and super PACs. Do you think the definition of express advocacy should be narrow? Do you think it should be broader? How broad is influencing an election in your view here?
Well, what we have now is not working. It's not really working for anybody. I don't think it's working for the public. I don't think it's working to ensure that voices can be heard in our elections. I don't think it's working to limit corruption. So then the question is, how do you get at it better? I actually don't know that the distinctions between express advocacy and functional equivalent of express advocacy, if I were going to fix it, I don't know that that's where I would start. I think where I would probably start is with the boundaries between entities that are engaging in that activity and people who are actually running for office, with the coordination rules. If you had really good, strict, well-enforced coordination rules and independent spending was genuinely independent, however defined, whether you use magic words or something broader, and anything that was not genuinely independent was treated like a contribution, which it functionally is, I don't think we would need to worry then very much about what exact trigger disclosure for that independent speech. So I guess that's not where I would focus in terms of refining the current framework.
This question of independent expenditures and coordination limits has become a bigger one in recent years, and I think it shows the difficulty of trying to have government take over this role. Of course, people are going to coordinate all kinds of things, and one thing that happened back in the battle days of the FEC was they'd constantly be trying to find coordination in what we might call parallel actions, right? But it's not hard if you want to do independent spending to know what races are competitive, to know what themes people are using, to know what ones make sense, right? Moreover, we want people, and they naturally will talk to their representatives. So a group that's very interested in an issue, let's say it's tariffs, right, will talk to congressmen about tariffs. And then they are likely to support for re-election congressmen who take their position on tariffs and oppose congressmen who don't take their position on tariffs. And to suggest that these groups cannot be talking to one another and cannot be seeing one another simply is not a workable solution. Suggesting that we can, somehow cut them off from the flow of information is not there. So now we do have walls, and these walls matter. I mean, you talk to people in politics, they don't like the coordination regs because it makes it harder for them to work with the candidates they want to work with, and it makes their spending less effective and less efficient. But does it, cut out the alleged corruption? Does it, solve those problems? Again, probably not, because I don't think you can do that and have something that you call a democracy. You can't say we're going to take these people, these 535 people in Washington, and lock them into a room where they don't get to talk to anybody around them. I just don't think that's the way it works. So, I think the idea that you can come up with a coordination standard that would solve all this, and the problem is just that we've cut it up with Swiss cheese holes, is kind of gets it backwards. We tried to come up with coordination provisions that halted all this, and they were a disaster, leading to endless litigation, suppression of different ideas, things that most people agree you really ought to be able to do, like if you run an interest group, talk to a congressman and find out about their voting record and what they're thinking about things. And once we get there, we're back to just complaining about it. So it's the same theme. All of these notions, these ideas, have to be implemented into law in some kind of codified phrase or series of judicial holdings or something like that. And as soon as you do that, the idea that you can have this nice, neat, closed system just really starts to fall apart.
I'll give an example. And I think this kind of goes to another just sort of difference of how one views the world. It's not, whatever standard you set is then subject to enforcement discretion. So if the standard is, you can't talk to the candidate and, exchange X or Y piece of information, give me whatever rule you want. The question becomes, what evidence is sufficient to investigate to determine whether or not that question happened? And we should note, the investigation is going to be expensive, it's going to be embarrassing, it's going to hit the papers, it's going to have political impacts. The existence of the investigation itself has pretty significant First Amendment implications. And so, I had a case where one of the pieces of evidence was a Republican candidate and an outside group both decided to take out ads during a college football game. And I'm like, well, yeah. Where would you take out an ad if you were supporting a Republican candidate? So you have those sort of things where, real people in real enforcement jobs are going to be squinting at the public evidence to decide whether or not to crack open these organizations. And I think one of the big practical issues in this area of the law is just, your average FEC person or, your average American who hasn't spent a lot of time around political campaigns has really no furniture of the mind for determining what is and isn't suspicious. And a lot of this stuff that looks coordinated is just common sense if you've spent 5 minutes doing this. And that's the other danger in the back of all of this.
Buckley spends a lot of time at the kind of close of the decision talking about a very easy topic of disclosure, right? It acknowledges that compelled disclosure can seriously infringe on freedom of association, but ultimately upholds the idea of disclosure as being a deterrent to corruption and providing information to the voters about who is influencing their elected officials. Citizens United later upholds that, and then we have recent cases like AFPF v. Bonta, which add a little bit more skepticism as to this idea of disclosure. What does Buckley tell us about the balance between individual privacy and the informational interest of voters or deterring corruption just through disclosure?
I'll defer to you, Alan. This is
I told you it was an easy one.
Oh, no.
No controversy.
I feel personally called out. Look, here's this is a great example of everything that's going on in the machinery of the opinion, right? It is very attractive to say, And let's back up, right? I mean, part of the court's analysis was, we've got this limit, you can only spend $1,000 on anything relative to a candidate. And the court is like, well, that's crazy. And they say as part of their kind of, just standard First Amendment analysis, okay, we're going to apply strict scrutiny. They didn't call it that because it was the 70s. We're going to apply strict scrutiny, and we're going to say what are less restrictive ways for the government to accomplish its interest? Or I guess the countervailing First Amendment interests of the people who elected the members of Congress, to take a different framing. How do we get at that? And the court said, well, this disclosure thing seems like it's going to accomplish a lot of what you want without this incredibly heavy-handed, we're going to throw people in jail if they spend $1,500 on a political ad, which makes a certain amount of sense, right? I get it. The problem is that, well, there's two problems. One, and this is the constant frustration in these debates publicly, is that the conversation is always about the big corporate contribution or the millionaire or the billionaire, but the contribution actual disclosure set is at $200, and it hasn't been adjusted for inflation. And no serious person thinks that makes any sense at all. So I always have this sort of skepticism about, oh, no, the disclosure is really saving the republic. It's like, really? Because, I'm pretty sure most of that's being used by neighbors who kind of want like an easement on their neighbor's land, or people like vetting the first date or looking at someone they're interviewing, right? Like this isn't being used to inform the average voter. In fact, I had a trial, to go back to this sort of, kind of theme of mine. It was a trial in Colorado, and the state had this expert, and the expert was there to explain how the press uses campaign finance reports to inform the people. And immediately admitted they don't look at any contributions less than $10,000. It's like, well, great, then what are we doing here, right? So I think Buckley was forced, or felt itself forced, to sign off on the concept of disclosure because it was a less restrictive means of accomplishing the government's interests. I don't think that has aged very well in a few ways. One, if you actually read the Federal Election Campaign Act, it says the commission is only supposed to keep records for 5 years. Like, that's what the law says. And instead it goes on a website and goes into a database forever. It used to be you had to actually go to the agency and pull this stuff, which means you probably were an actual reporter or someone who was involved in politics. Like, you had a need to know the information in national security parlance. And that's a real protection for the privacy of the people who are in those reports. Now it's on the website forever and amalgamated and put into like searchable databases and sliced and diced within an inch of its life and made part of the public package of everyone who's ever given $1 to anybody. I don't think that's what Buckley had in mind. I don't think that meaningfully accomplishes any legitimate governmental interest. And in particular, because you were kind enough to give me the softball, this concept of the informational interest, I think, does have some attraction. That if someone's giving a $10,000, $100,000, $1 million contribution, that probably does affect how people are going to think about the person, to Adob's point. I don't think that's crazy. The problem is that I am not aware of a single law anywhere in the country that has even tried to set the levels for disclosure at those kind of material levels. It is always, we need to be able to track that 5-cent contribution, because what if it's the Chinese government just kind of trying to take over our country in 5-cent increments? I don't know what to say to that, except that if that's your theory of the world, I don't know how you take seriously the countervailing interests and privacy of association and belief protected by the First Amendment, which was, the central victory of the civil rights, movement in the NAACP line of cases, is foundational to how Buckley thinks about an independent civil society. I don't see how you can give that interest any weight and believe in the current system of disclosure laws.
I think there is a widespread perception that the purpose behind disclosure laws is so that individual voters can go on the FEC website, see who is funding a candidate, and make a voting decision based on that. And I agree completely with folks who say that does not happen in real life. That is not the purpose of it, and I think it's a straw man to set that up as the purpose and then say disclosure as we have it today is not fulfilling that goal because it reaches too many people. The purpose of disclosure is, or the way disclosure actually works in the real world, is it's used by the media, it's used by organizations that do corruption watchdogging, and it's used by law enforcement to detect corruption. to find irregularities, to find illegalities, and it is the only thing we have for that. So particularly in a world where most of the money that comes into the system is not regulated on the spending side, that's all we got. And if we don't have that disclosure, we are going to be completely unable to detect impropriety, illegality, and corruption. Should the thresholds be adjusted? Sure, of course. They haven't been adjusted for forever, and if we had a functioning Congress, which, by the way, we partially don't because of these issues, if we had a functioning Congress, they would have done that many years ago. But whether it's 200 or 500, that's really insignificant in the grand scheme of things. The point is that the availability of this information for the people who actually use it is key to detecting, deterring corruption, and informing the public.
I want to take issue again with one other thing. Sometimes I hear this argument quite a bit that, you know, things will be adjusted, things will be, you know, we just need to adjust the thresholds upwards on contributions or whatever it is. I just want to point out that this is a different sort of real world impact. But in the real world, the reform community, the coalition of groups, generally well-funded groups that have promoted regulation in this area, resist every effort to raise thresholds, including the disclosure thresholds. And indeed, they're often quite the opposite. We need every penny disclosed instantly on the internet. You know, they're constantly pushing lower. The individual giving limits were raised in McCain-Feingold only because it was absolutely necessary to get the last couple of votes to push it over the threshold in what reformers would otherwise in any other situation call grotesque bargaining of special interest, right? But that's what was needed to get it over the threshold, was to agree to raise those limits. They were raised by about half of inflation at that time and then adjusted for inflation. Other limits were not adjusted for inflation at all. And you know, on the disclosure side, I mean, I don't doubt Ada's sincerity here for himself, but that's not the way it works in the real world. In the real world, it's lower, lower, lower. And that's what we have to remember. That's why I say so you know, importantly at the outset, Buckley saves democracy, because what people want, what the reform groups driving it want, is an end to democracy. They don't want their representatives talking to people. Access is corruption. They don't want people talking to other people, $1,000 relative to a clearly identified candidate. They want to expose and, quote, hold accountable, is the phrase now used, people for giving to the wrong candidates. Okay? That's what this is about for far too many people. And the First Amendment and our policy judgments have to take that into account. We cannot pretend, again, that this is all, you know, just great, you know, puppies and roses again, and it's going to be just a wonderful world when we have all these restrictions in place. People want these restrictions for the same reasons they want lots of other things, and it's not always, you know, because it's wonderful for everybody in the room. It's something that they think is good for themselves and their own political power, and that's why we have a First Amendment. That's what it comes down to.
I mean, I'll also just, because there's a wide range of experience in this room, like we somehow catch spies and put people in prison for public trading and insider trading, and we like catch securities fraud, and we break up drug rings, and we do all sorts of law enforcement without public disclosure at the $200 level. So I think it is obviously wrong that that is the only way to enforce the laws.
Would you like to respond, or would you like to go to
Just
audience
just on that last point, there is a vigorous anti-espionage function within the federal government. There is not a vigorous enforcement function within the federal government for any of these, for the campaign finance issues we're talking about today.
Public integrity would be very disappointed to hear you say that.
Thank you all. I think we have a few minutes left for Q&A from the audience. If there's anyone who has any questions for the panelists.
Yeah, I'd like to ask each of the panelists to speculate a bit. We've talked about the past of Buckley v. Valeo, but the future of Buckley v. Valeo, when, in my view, and I was a committee counsel for many years to the Committee on House Administration and House of Representatives. And there are a lot of people that think that the inevitable next Democratic trifecta will probably get rid of the filibuster and add some new justices to create a new majority on the Supreme Court. And I'd like each of you to speculate on what kind of campaign finance law we will have after that, in my view, very likely outcome in the next few years. Thank you.
That is so far above my pay grade. Well, I will say this. I have a friend who pretty consistently predicts Supreme Court justices' votes. And his heuristic is really simple. He assumes that they're in earnest and that they mean what they've said. And it's amazing how far, I am not a cynic in the sense that I do think legal argument matters. I think that the thrust of the arguments in Buckley are compelling, broadly compelling. I mean, again, we heard how Justice Kagan has invoked Buckley in related contexts, where she's distinguished it. She's been, very forthright about, the power of the original opinion and its role as precedent. So I will, without reaching the merits of your question, I will say that I do think that, many of these arguments have their own force, and that lifetime appointed Supreme Court justices have a habit of disappointing the people who appointed them when they expect, people who have dedicated their lives to the rule of law to suddenly switch on that.
Yeah, I don't know that I can speculate as to what would happen after a sort of hypothetical future election, and then legislation hypothetically changing the court, and then other legislation, and then what happens to the court. I think that's too many ifs to responsibly speculate on. I think it's pretty clear, though, where the priorities would be in terms of fixing the system. I think we've touched on many of them today. It's clarifying what should be disclosed and what doesn't need to be disclosed. It's fixing the coordination between super PACs and candidates. I mean, I don't think any of this is a secret. So I would expect that those would be the focus of initial legislation. And ultimately, I actually think if in this scenario, it's not really about legislation. It's would a future Supreme Court think that Citizens United was rightly decided? And I think a future court would likely find it was not rightly decided. And then, of course, we're in a very different, jurisprudential framework.
Well, yeah, I mean, one of the reasons it's hard to speculate too is the court's affected by the cases that are brought before them. So if you take Citizens United, I mean, I don't want to start a whole nother case here, but I think the thing that drives people on the left nuts about Citizens United is that it's so obviously a correct decision. I mean, the government's position was that it could censor a documentary movie about a major presidential candidate during an election year because the movie was at some point distributed or produced by a corporation like every other movie you have ever seen on streaming, DVDs, cable, broadcast, YouTube, anything other than a home movie. And even that, I suppose we could say there was corporate involvement in production of the cameras and film and stuff like that. It's just absurd. But think about how Citizens United might look differently had the government come in. Remember, it was illegal to spend a nickel, a penny for a corporation to advocate for somebody, right? So if an executive, asked his secretary to drop a personal letter he wrote to somebody saying, hey, I think you ought to give $1,000 to Mitt Romney or something like that, right, into the mailbox, that was like an illegal use of corporate resources. Suppose instead the law had said something like, well, a corporation can't spend more than $1 million. Or 10 million or some realistic kind of number that would communicate with a bunch of people, I think the case would have looked different to the court. Would you have gotten the same result? If you read Justice Kennedy's opinion, the answer is clearly yes, but I'm not sure that he would have written the same opinion. I like to think he would have, but the cases will look different, so we'd have to see what actually comes up. But I do think over time these cases become more durable, even Citizens United, they become more durable. The flip side is that people always have a distrust of wealthy. They will always have, sometimes it's just envious, but that's often it's distrust. Often it's very, very well-earned distrust. And they will always, have reasons to be suspicious of money in politics, and this battle will go on for a long time.
Have any of you seen any implications of Buckley for commercial speech?
Well, I've not thought much about that question, so I don't have a very good answer, but I will note one thing, which is, again, that appearance of corruption that Buckley has. On the commercial speech, the court's actually been pretty good about saying, you've got to show government an actual problem, not just the appearance of it. So I think that's just an interesting dichotomy there, that in that respect, at least, the evidentiary burden seems higher on the state on commercial speech than on core political speech. Of course, I think both should be protected, but we'll leave that.
If I can ask, just, isn't this all sort of downstream of the growth of government power, especially the federal government power? I mean, I will credit that I think there's a very real concern about corruption in politics and about just the enormous amount of money, I think, that people want to spend to be able to influence politicians. But isn't that basically all just downstream of the fact that we have a government that has an enormous amount of power? And if you have that kind of power, then a lot of people are going to feel both the desire and the need to spend their resources to try to make sure that it doesn't harm them with all the tools that it has. So basically, couldn't you address this on the demand side by saying, let's make government less powerful so that many fewer people will want to devote many fewer resources to trying to influence these much less powerful people that could have an impact on my life?
Well, you're certainly a dreamer, aren't you?
I guess I would question the premise that if you decreased government or federal government power, people or entities would care less about what their government does, especially individuals. I mean, I think it's baked into us as Americans. We care a whole lot. And I don't know that you could empirically demonstrate that the growth of the federal government has led to more people caring more about their government and how it's run. So I guess I don't know that would have that effect. It might have the effect for certain like corporate spenders. If they're just not regulated anymore, then they're not going to need to participate in the system. But I think for individuals and for issue-based collections of people, I think that sort of effect might be pretty modest at most.
Well, I think make government less important is a great point to end on, but we've run out of time, so I want to thank our panelists, thank our moderators, especially Brad for doing double duty, and thank you all for coming today. We're adjourned.